Here.
Commissioner Jackson,
Here.
Chair Lee,
Present.
Councilmember Brost, Mayor Boland.
So moving on, tonight's agenda, we're going to open it up with department remarks. We have a public comment session, presentation by City Attorney John Young, and then a discussion on new urbanism. So does the department have any opening remarks?
Yes, Mr. Chair, with your permission. Mr. Chair and members of the Planning and Zoning Commission, first and foremost, thank you for attending tonight. We do appreciate it very much. We recognize that we don't get a lot of fifth Mondays, which is an opportunity for everybody to kind of relax. But we've chosen over the course of the last couple of years to use our fifth Mondays as opportunities to get together, to talk about different things and do it in a more informal setting. Tonight, Mr. Young, our city attorney, will be providing you some training tips and information that he's garnered over his long career working with different municipalities and their planning and zoning commissions. We're very fortunate in that Mr. Young does this for the Missouri Municipal League and many other organizations, and we get to have him here tonight as part of our group and as always part of our group. So we're getting the expertise, so to speak, free. Thereafter, the department thought it'd be appropriate with so many new members that have come on recently to get a little primer on town center. Not so much about the history of it, I will touch upon it briefly, but there is a town center update team that has been working now for almost 2 years. Ms. Helfrey is part of that group, and I believe Mr. Beatty as well. I could be mistaken there, I apologize. But it's an opportunity to kind of update you on what they've been doing, the direction they're heading, and then to just give you some background information that hopefully will help you as we discuss the upcoming reserve at Wildwood proposals and others that may come in town center. As I mentioned, I think Mr. Young agrees that this is kind of an informal meeting. We would love to have you ask questions and respond to your comments. It's a learning opportunity for us all. Mr. Newberry, Ms. Arnett, Mr. Young, and I, we like to think we explain things well, but we always don't. And so if we're not making it clear, stop us and make sure we do. Mr. Chair, that's all I have. And again, thank you all for coming tonight. Oh, one other thing.
Oh, go ahead.
See at the bottom of my screen, I'm not sure where it is on yours, Trey is here. Trey is a high school student that's been shadowing Mayor Boland over the course of time. And he's going to be at our next couple of meetings, and we welcome him, and thanks for showing up.
Welcome. Mr. Newberry, public comment session.
Yes, sir. As I mentioned, we do have a few in attendance tonight. So if anybody would like to provide a comment at this time, they would use the raise hand feature in Zoom. We will promote you to a panelist, and we'll just give it a few moments.
Mm-hmm.
Doesn't appear that anyone's raising their hand via Zoom. So,
Okay, well, we'll move on to City Attorney John Young. Floor is yours.
Thank you, Mr. Chair. I have a presentation and I'm going to do my darndest to share my screen right now. And I am clearly failing. Let's see here. Okay, I think are we up? Can you all see my screen?
sir.
Yeah.
Okay, great. All right, well, I appreciate the opportunity to do this. I always find this exercise helpful. What I'm going to do today is kind of go at the talk about zoning from the legal perspective, kind of at the 10,000-foot level. As many of you who have been around for a while, and even those of you who haven't been, zoning is a very complex area of law that deals with a lot of issues. And part of the complexity of it is that it's very specific to the piece of property. So not the analysis from a legal perspective is never or rarely the same. Sometimes similar and the principles are the same, but the application is often different because of the unique nature of individual pieces of property. But my hope at the end of this is that everyone will have a general understanding of some of the terminology when we use it, some of the basic concepts, and at least you may not give you the answers that you always need, but it'll help you ask some of the questions as we go forward in this zoning process. I will say the subtitle here is why Euclidean zoning has nothing to do with geometry and other important issues. That's a little bit of a joke on wordplay that I'll explain in a little bit. All right. So let's start with a little bit on some of the basic vocabulary. When we talk about zoning, we also use the terminology of land use law. And this is the generic terminology applied to regulation governing physical planning and land development. So that's your zoning regulations, that's your planning, that's your platting, your setbacks, uses, all of it. It all goes into land use. And the key players, as you well know, are the City Council, the Planning and Zoning Commission, the Board of Zoning Adjustment, which is your Board of Adjustment, and then the City Department of Planning. Interestingly enough, while you all don't have a whole lot of interaction with the Board of Adjustment, which is intentional from a legal perspective, it's interesting to note that you can't have zoning without a Board of Adjustment. Missouri law requires you to have a Board of Adjustment or you cannot have zoning. So just a fun, interesting fact for you. So here's where the Euclidean zoning crack comes from. And I'll tell you a little bit of an embarrassing story. When I first started practicing law, I've been practicing law for 17 years and doing zoning law the entire time. And when I first started practicing, they don't teach zoning law really in law school. It's very, we don't get a lot of it. And we started hearing this term Euclidean zoning. So I'm thinking, all right, yeah, Euclidean zoning, you put things on a piece of paper, there's lines being drawn, shapes are formed in this. It's got to have something to do with geometry. And in fact, it doesn't. It comes from a Supreme Court case, United States Supreme Court case from 1926 called Village of Euclid, Ohio versus Ambler Realty Company. And the interesting thing about this case was before the Supreme Court made a declaration in this case, zoning was unconstitutional. This is the first time in 1926 that zoning was declared to be constitutional and not an unconstitutional taking of property. Because if you think about it from a logical perspective, zoning is a restriction on the use of property. So prior to 1926, the prevailing law was attempts to zone or regulate property in a zoning type fashion was an unconstitutional taking. The United States Supreme Court in 1926 finally said, no, you can have reasonable regulations on the use of land. So I like to start off with that because zoning as a general principle in the United States, hasn't always been around. It's something that was unconstitutional in this country until 1926. Another terminology, which is actually a statutorily defined term, is transect-based zoning, which you're going to have a talk about it later tonight about new urbanism. And transect-based zoning is part of the fundamentals of new urbanism. I'm not going to go into a whole lot of detail of this. I thought it was fun to put this in here because this is the only type of zoning or planning practice that is statutorily defined. And it was defined in 2007 in a statutory amendment. So in terms of the city of Wildwood's application of transect zoning or new urbanist principles in the 1990s and early 2000s, you guys were way ahead of the game on this trend. Now, one other way I like to start any of these conversations is to talk about the general primary rules. I think this is important to read in its entirety. One of the primary rules of construction in this state is that zoning ordinances being in derogation of common law property rights should, whenever ambiguous, be strictly construed in favor of the property owner. Where a term in a zoning ordinance is susceptible of more than one interpretation, the courts are to give weight to the interpretation that, while still within the confines of the term, is least restrictive upon the rights of the property owner to use his land as he wishes. So when I talk about 1926 Village of Euclid, Missouri interpretation says you have to be very specific and explain your regulations. And if there's any ambiguity in it, the law is going to fall on the side of the free use of land. That's why when we talk about the preparation and we take so much time reviewing zoning regulations, we give a lot of detail. And the reason we give a lot of that detail is so we don't have the ambiguities in those laws. Next concept I want to introduce is, what are the sources of municipal law? Why are cities allowed to do what they do? Well, as you know, the city of Wellwood is a constitutional charter city. So you are a city. The Missouri Constitution provides that cities with a population of at least 10,000 may establish themselves upon a vote by the people as a charter city. City actually incorporated as a third-class city, which is a statutory city. But when it comes to sources of municipal law, those powers come from the Constitution, state statute, and ordinances. And it's important to recognize Dillon's rule. This is a legal principle, a national legal principle of Dillon's rule. It says Missouri cities have or can exercise only such powers are conferred by express or implied provisions of law, their charters being a grant and not a limitation of power, subject to strict construction with doubtful powers resolved against the city. So what are the city's powers? It's those granted in express words in statute, those necessarily or fairly implied in or incident to the powers expressly granted, and those essential to the declared objects and purposes of the corporation, not simply convenient, but indispensable. Any fair, reasonable doubt concerning the existence of power is resolved by the courts against the corporation, and the power is denied. So whenever I analyze a proposed regulation of any sort, whether it be zoning or not, the first question is, can we do it? And we have to make sure we have the actual authority to do it, not that it's necessarily unlawful, but that there is some grant of authority to do it. So we talked a little bit about being a charter city, and a charter city has a lot more authority and a lot more freedom than like a third class or a fourth class city, but there are still limitations. All city ordinances have to be consistent with the Constitution, and they cannot be limited or denied by state statutes. The general rule to apply on whether or not you can do something, and if it's consistent with state statute, is you cannot enact a law that permits what a statute prohibits or prohibits what a statute permits. And if a law is deemed to be, if an ordinance is deemed to be in conflict with law, it is void and unenforceable. All right, so there are some general principles about the application of law to cities. Now, specifically with regard to zoning, Missouri has Chapter 89, that is known as the Zoning Enabling Act. Cities are allowed to zone only because that statute exists. The state said, we are granting to cities the ability to zone property. And Chapter 89 is the sole source of authority, and charter cities must comply with the provisions of Chapter 89. Now, there's other limitations on zoning authority other than having to comply with the Zoning Enabling Act. You've obviously got the United States Constitution, which includes physical invasions, regulatory takings, either total or partial, exactions, Dedication requirements and impact fees, those are monetary or property exactions. And then vested rights. So rights, the term grandfathering is used a lot in zoning when we change an ordinance. What that really is from a constitutional analysis perspective is a vested right, meaning I've already got the right based on the old law. You can't now change the rules of the game when I'm already playing. You've also got free speech considerations. So you got political speech, commercial speech. You also have the Missouri Constitution. There are specific regulations of the Missouri Constitution. Missouri legislation going back to the Zoning Enabling Act. One thing that a city cannot do, and you'll notice this if you go through the city, there's no regulation about where churches are permitted. That's because the Zoning Enabling Act does not provide for the regulation of churches. So churches can go wherever they want, subject to, police power, planning, setbacks, things of that nature. Then you also have federal legislation that you're subject to. The Americans with Disabilities Act regulates certain zoning considerations. We passed a law several years ago. Some of you remember we did some amendments on group homes. That was because of ADA requirements and also FHAA, Fair Housing Administration Act. RLIPA is a Religious Liberties Act, which limits the ability to regulate churches further beyond the limitation on the authority of cities in the state of Missouri. And then you also have the EPA, the Environmental Protection Act. And there's a number of other federal laws that are also implied. And then you have decisional law. What I mean by that is the case law that analyzes zoning from a common law aspect as well as statutory interpretation. So the first thing you do, first things first when it comes to zoning is your plan, the plan. Oftentimes referred to as the city plan, the master plan. In Wildwood, you hear a lot about the comprehensive plan. Comprehensive plan is your guideline, your guide for the development of the city. And that is a statutory requirement. Everybody that has zoning has to have a comprehensive plan. It's adopted by the Planning and Zoning Commission. So by statute, the Planning and Zoning Commission adopts the comprehensive plan. It is a general guide to future development. It doesn't actually impose restrictions except as tied to zoning regulations. And adherence to the plan constitutes a factor in determining the reasonableness of a zoning regulation. Now with the city, and especially with regard to the city's portions of the city's plan, which are really tied more concretely to the zoning ordinance, it's a stronger factor and much more, carries much more weight. But what I want you to learn out of this is if you follow your comprehensive plan, generally you're going to be fine in your zoning decisions unless it's unless there's an error or issue with the comprehensive plan in its own right. So we're going to talk a little bit about the three types of actions in planning and zoning. So when I say actions, the types of votes you make, the types of things you as a commission do, or even the city council does, or the Board of Adjustment do. There's three categories. There are legislative acts, there are administrative acts, and there are ministerial acts, okay? And here I'm talking more on the final actions. You are a recommending body to a certain extent with a number of things, such as zoning amendments or regulation amendments or adoption of regulation. You're a recommending body. The three types of actions I'm talking about here fall more in the category of final action, so approval of something. So I'm going to start with legislative acts. And what is a legislative act? A legislative act is prescription of a new policy or plan. So this is your rules, your regulations. The generally recognized definition of a zoning ordinance is an ordinance which regulates the use of land and buildings according to districts, areas, or locations. These actions have to be taken by the city council and are afforded a great deal of deference by courts. So only the city council can take legislative action. And there's types of legislative action. There's original zoning. So the first zoning ever that happened back in 1995, there was a whole different procedure, statutory procedure for the adoption of that first zoning ordinance, those first zoning regulations, and the application of those to the property in the city. And then everything thereafter is an amendment to the city's zoning regulations and zoning map. Again, there's exceptions, and we talked about these a little bit. You have no authority, the city has no authority to zone religious uses, and sometimes other governmental bodies. There's a whole complex analysis of whether or not a city can do something outside of its boundaries in another city and use land outside of its city, and whether or not they have to comply with that other city's zoning regulations. Missouri courts aren't even clear on what the rules are and what the test is to apply to that. They've used over the course of 60 years 3 different tests, none of which have really been clarified as being the one test to apply. But I think it's safe to say that one prevailing test is this. So say, for example, the city of Wildwood wants to put a dump in the city of Chesterfield, a trash dump. If the city of Wildwood has authority to condemn property using eminent domain to use that property or acquire property for that purpose, generally you're going to have priority and you won't have to comply with the zoning regulations of the city of Chesterfield. Again, different situations call for different things. It depends on what the uses are, but you don't always have the authority to zone other governmental bodies or political subdivisions. And for legislative acts, procedural requirements are very important. Where the procedural requirements of the Zoning Enabling Act are not strictly complied with, the ordinance is invalid and cannot be enforced. So when we harp about the requirements of making sure that notices have been published, public hearings have occurred, the reason you do that is because state law requires it, and a failure to comply with those requirements will render the action void, whether it be a zoning amendment to a piece of property or the adoption of a new zoning regulation. So let's talk a little bit about public hearings. And, first of all, why do you have them? Second, what is their purpose? First, from a statutory requirement, you have to have 15 days published notice. Statute requires 15 days notice published in a newspaper of general circulation. That's it. That's all state law requires. Now, city code has additional requirements for that notice, and we'll get into that in a moment. What is a hearing? A hearing is a session in which testimony is taken from witnesses, an opportunity to be heard, to present one side of a case, or to be generally known or appreciated in a listening to arguments. Now, some of you may remember several years ago, about 5 years ago, in Franklin County, there was a big dispute about a coal ash plant that was being proposed for construction. And they were considering amendments to their regulations. Well, folks wanted to stand up and talk about the proposed plant because the regulations related to trying to allow that plant. Well, the county commission said, nope, we're not talking about the plant, we're talking about the regulation, and stopped people from talking about the plant. Well, the court said, well, then that's not a true public hearing. You have to allow people to talk about it even tangentially. So as a general principle, allow people to say what they want to say as long as it's even relatedly germane to the topic at hand. Because you don't want to have something overturned because you didn't let someone speak because you either didn't like what they were saying about it, or you thought it was not specific enough to the proposed regulation. All right, so as part of that public hearing, you have to have the notice. So you've got the 15 days by statute. City code requires that as well. In addition, requires a sign be posted on the property 15 to 21 days prior to the public hearing, mailed notice to properties within 3,000 to 5,000 feet, and apply to hearing for both P&Z and these regulations, these notice requirements apply to both the hearings for both the P&Z and the city council. So the city requires hearings before P&Z and the city council. State law only requires it before one body. Now, in practice, most cities that I work with do it in front of both bodies, both the P&Z and the city council, but it is only required by statute to do in front of one. Now, for the city, those are only for rezonings. For a text amendment, so an amendment to the city code and your regulations, the published notice is sufficient. So the 15 days published notice. It is worth noting that the city code, and I think this is prudent, that failure to follow any of these additional notice requirements will not invalidate any action taken. So we have to follow the statutory procedure, the 15 days published notice, but all the other notice requirements, which are, in my experience, more onerous than most cities, which is great for the city. I mean, you guys communicate more than most cities I work with or deal with. And I say that as a good thing, because communication is always good. You can't get in trouble for too much communication. All right, when dealing with legislative acts, so you're enacting zoning ordinances or you're amending a zoning, what standard are you subject to legally? Okay. Now, a common misperception is people say, oh, if we don't approve this rezoning, they're going to sue us because they're entitled to have their property zoned to something different, from R1A to R1B, from non-urban to an R district, or non-urban to commercial. If they prove a good case for it, they're entitled to it, right? They say, hey, this is much more beneficial, it'll increase property value. It's good for our ownership. Well, the actual standard that a court looks at is you're not challenging the denial of the zoning that you want. You're challenging whether or not the zoning you have is unreasonable. So for someone to say, you have to rezone my property, they have to prove to a court that the zoning they have now is unreasonable. And the helpful thing is we talk about, and I've mentioned about the zoning regulations and what happens if you have an ambiguity and the preference for the free use of land. Courts in Missouri have stated that zoning ordinances are presumed valid. So you begin with the presumption that a zoning regulation you have is valid. And anyone challenging that regulation or that zoning applied to their property has to defeat that burden, overcome that burden of that presumption. And they have to prove the unreasonableness. You don't have to prove it's reasonable. They have to prove it's unreasonable. So they bear the burden of proof. And no one factor is dispositive in balancing public versus private interests for purposes of zoning regulations. And this is where I talk about the complexity of zoning is the decision of each case rests upon its own particular facts and circumstances. So not every thing is going to be applied the same because of the inherent uniqueness of each piece of property. Now, one thing also that I think is relevant to a legislative act is this: motives are largely irrelevant. So when it comes to a rezoning, you don't technically have to say anything. You don't have to justify why, because your motives are ultimately legally irrelevant. You could have a hearing on a rezoning and have the P&Z or the city council say nothing at all and approve or deny it. And that's okay. Now, the one caveat to that is the motives cannot impinge on the rights of individuals. So if the motives are, racial animus, or something of that nature, that's problematic. I know some of you have heard, we can't ask questions about the price points of residential developments. And part of the analysis there is, it's not a hard and fast rule that you can't. It's that there have been some cases that have said that is evidence, not conclusive evidence, but evidence of racial animus. So it's good to avoid, except to the extent of, look at, when you're talking about price points, what you're really trying to get at generally or typically is preservation of property values. And you could do that by the materials they're using, the size of the lots, the size of the homes, and you all do a very good job of that. And the city is very detailed, and the department does a great job of making sure all of that is retained to help retain the value of properties within the city, to retain those property values. All right, and again, when you've been denied a rezoning, the property owner has to overcome that decision and evidence which rebuts the presumption of validity, and there's no contrary evidence that the decision of the city is a fairly debatable exercise of its authority to zone. Yeah, the fairly debatable standard for cities is a nice standard, and what that means is if they come in and say, hey, court says, hey, property owner, you've made some good points, the city's also made some good points, and we could go either way on this, and because we can go either way on this, city wins. So again, cities really got the upper hand when it comes to these type of actions, legislative actions. Now, I do want to point out just a couple of cases that, just some factors about what are or are not valid, legitimate reasons to either approve, deny zonings. Now, these courts have found that these reasons alone were insufficient to deny a rezoning. The denial of a previous rezoning application is not a sufficient basis to challenge a later rezoning of the same property. So that's your only reason. I can't go to court and say, we denied it because 5 years ago they denied it. If I come up with that argument and they've overcome the rebuttable presumption, I'm going to lose that case. Another one is an attempt to regulate or prevent competition is an insufficient reason to deny a zoning change, because zoning ordinances are not intended to confer business monopolies on individuals. The idea here is, oh, well, there's already a restaurant right down the street and we don't want them to lose business. That's not a legitimate reason to deny zoning by itself. You could have all sorts of other reasons. That's not one of them. And that there was no immediate plan to use the property, but rather only a desire for commercial zoning is not considered fatal to the applicant. I think that case is probably a once-off because they ultimately, remember, they have to come in and say the zoning of my property right now is unreasonable, can't be used, and takes away all economic use of the property. I have to be able to use it for commercial. What this court says is the desire to use it for commercial without knowing who the user ultimately is going to be is okay. You don't have to always know who the user is going to be, as long as, as long as you still prove and overcome that burden and defeat the presumption. Here are some sufficient reasons. My favorite, and the one that you're always going to be okay with, is incompatibility, if I can say it, incompatibility of proposed use with surrounding uses. That's pretty much the cornerstone of zoning, is to make sure properties are compatible with their neighbors. Showing a mere difference in value under different zoning does not establish a private detriment substantial enough to require a zoning change. So if it's a property that residentially is worth $500,000, but commercially is worth 1.5 million, that doesn't necessarily mean that's enough. Just because you can make more off it does not mean the zoning regulation is invalid or unreasonable. So that's legislative acts. So the next one is administrative acts. So remember, legislative is the adoption of the law, the implementation of the plan, the legal plan, or the creation of the legal plan. This is the implementation of that plan. This is carrying out the plan. I like to use a Jerry Seinfeld quote and apply it to zoning. Jerry Seinfeld described law as everybody playing a board game and the lawyers being the one who's read the top of the box. And I like that analogy, especially as applied to zoning. If you think of zoning or the city as a monopoly board, okay, you guys write the rules on the top of the box, but you also have the requirement to apply and analyze those rules that are on the top of the box. Now, one thing that's important is even if the city council acts, it is still an administrative act and these type of things. And examples are conditional use permits and site plans. If the city council acts on one of those, it is an administrative act because they're delegating to themselves the authority to approve and analyze those applications. So administrative acts include, the actors are city council, planning and zoning commission, and the board of adjustment. Now, the biggest difference between legislative and administrative actions is the amount of discretion. Where in legislative act, there's a great deal of discretion afforded for legislation because you've got that rebuttable presumption and the courts are not going to interfere with your discretion. Now, when it comes to administrative acts, there have to be rules. And when the legislative body of the city chooses to delegate itself the discretionary power to enforce its regulation, it acts administratively in acting on the applications. Same with the Planning and Zoning Commission, you are acting administratively. So you are applying a preset rules to an application, such as a site plan or conditional use permit. So administrative authority, the city council can't say, we can approve whatever conditional uses we want because if we want to or not, or the Planning and Zoning Commission, we're going to just say, you guys approve whatever you want. They can't do that because that is an unlawful delegation of legislative authority. They have to establish rules. There can't be just a do whatever you want and we'll go along with it. It's here are the rules, here are the standards, here are the rules on the top of the box so that everybody knows what the rules are and can play by those rules. The standards have to be specific enough so that an administrative body cannot arbitrarily grant permission to one person while denying it to another similarly situated. Remember how we talked about ambiguity. What happens in the case of ambiguity? If it's ambiguous, it's going to be, courts are going to say, we're going to apply it in the favor of the free use of property. So specifically with conditional use permits, first, it's interesting that there's no statutory authority for cities for conditional use permits. There are for counties, but not for cities. But we're allowed to do it because it's consistent with the law. It still falls within those authority under Dillon's rule. Conditional use technique developed as a flexible means of controlling uses considered to be essentially desirable, necessary, or convenient to the community, but which by their nature or operation are regarded as troublesome in terms of traffic congestion or potential hazards to the public health and safety. So it's not a, do we want it here or not? It's, there are hazards essential and inherent with a particular use of land, and we want to make sure those get addressed. That we, so much so that we don't just want to allow them as a matter of right. And a conditional use permit allows a property owner to put his property to a use which the regulations expressly permit under conditions specified in the zoning regulations themselves. And again, this is worth bolding, underlining, in all caps. So I'm yelling in words. A conditional use permit is not a rezoning. And I know you all know this, but you'd be surprised about how many people don't. I remember when I first started representing one city, they just thought it was they could do whatever they wanted. They could just grant conditional use permits that for uses that weren't even listed in their code. And you can't do that. This is an administrative process. And the fact that, as you know, the city code provides that the city council approves conditional use permits by ordinance. And ordinances are generally legislative acts and follow legislative procedures. But it is still an administrative action of the city council, even though the city code requires that it be approved by ordinance. And you cannot vary from the zoning ordinances by use of a conditional use permit. And if the applicant meets all of the requirements in the zoning ordinance, the Board of Aldermen or City Council is without authority to deny the permit, or the Planning and Zoning Commission as well. So if they meet all the requirements of the city code, for example, you've got your list, and we'll go through the list of requirements. If they meet all the requirements, but it's something you don't like, you can't deny it because you don't like it, if it meets all the requirements. All the more reason when we have these regulations and we consider regulations, that's why we want that specificity in those regulations. All right, so what are the standards we apply? Here are the standards in the city code for a conditional use permit. So the Planning Commission may permit those developments and uses only where such developments and uses are deemed consistent with good planning practice, can be operated in a manner that is not detrimental to the permitted developments and uses in the district, can be developed and operated in a manner that is visually compatible with the permitted uses in the surrounding area, and are deemed essential or desirable to preserve and promote the public health, safety, and general welfare of the city of Wildwood. Those are your standards. And each conditional use permit that you consider should be considered applying those standards. Now, the petitioner has the burden of establishing that the requested use satisfies the standards and that there's a public necessity for the use. So the standards, applicant bears the burden of proving it. You don't bear the burden of rejecting it. They bear the burden of approving it or proving it, proving that they meet all the requirements, all of the standards. I will say, some of you may know, some of you don't. While most of my work is working for cities, I have done work on the other side of the dais for property owner clients in other communities. And it's not uncommon that we will prepare a document and submit it to the Planning and Zoning Commission that says, here are your standards, and here's how my client has met all your standards in the evidence we have presented. So here's the practice. Now, many of you know, those of you who have been on since 2018, remember that several years ago, we amended the process pursuant to which conditional use permits are approved. Now, in amending that process, you probably haven't noticed a difference because the process at the planning and zoning stage hasn't really changed. It has fundamentally and for all practical purposes remained the same. But there is a very significant difference. And the reason I explain this to you, even though you don't have a role in the second portion of this, I think it is important to know the entirety of the process so that you really understand how important what you do is. So the first step is planning and zoning consideration of a conditional use permit. Application and notice. So we talked a little bit about the application and notice for zoning amendments, and for the conditional use permits before the Planning and Zoning Commission, it's exactly the same thing. You approve or deny the application. So you approve with conditions, so you can add conditions, and you typically do. And you file a report with the City Council in which the Commission shall grant or deny each application for conditional use permit and state the reasons for therefore. So in the document that you all review, amend, and ultimately adopt, that's your report to the Planning and Zoning Commission. And the planning staff does a great job of giving you the support to present all of that information in the consistent with what the code requires. Now let's talk about the second step. So you've given your recommendation, or you've actually approved it. You've approved or denied the conditional use permit. The next step in the process is that it can be appealed or reviewed by the city council. This is not something that automatically happens, which is which is a change. Well, no, it's not a change, but it doesn't automatically happen. It can either be a petitioner can appeal the denial. Nearby owners, property owners can protest the approval. Those nearby owners being owners of 30% by area within 185 feet of the subject property. And the city council may elect to review the approval or denial of a conditional use permit. And there are time limitations on when these must take place. Petitioner has 30 days to file their appeal. Nearby property owners have 18 days. City council has 15 days from the day it was presented to them. So the date of the city council meeting at which it is first presented. So appeal's been filed by, or protest, or the city council has decided they want to review. Process is notice of a hearing has to be mailed to the interested parties, necessary parties, 10 days before the hearing. And I want to point out the difference between a hearing and a public hearing. What you have before you at the conditional use permit process is a public hearing, okay? It is everybody getting to say what they want. We don't record it. We don't have a court reporter there typing it out and making a record of it. A hearing is different. Think of it more in the context of a court case where you're presenting evidence and you've got different sides to the case, as opposed to everyone just giving their opinion on one thing. It's you've got sides and you're going to argue that case. And it's much, much more formal in its procedures. There's oral evidence, sworn testimony. So people are sworn in when they give their testimony. There's the opportunity for examination and cross-examination. You can object to questions or the presentation of evidence. A court reporter or some form of recording of the proceedings must be made. Written briefs are allowed. Now, all of this can be waived by the applicant or the property owner, but these are allowed and our city code expressly provides for them. In addition, one of those property owners, neighboring property owners, can also intervene in the case, meaning, let's say, for example, the applicant filed an appeal because they got denied. Well, the property owner who was opposed to it can say, hey, I want to be part of this case. I want to be able to examine witnesses, present my own evidence, object to the presentation of evidence. They can intervene, and there's a time frame within which they have to do it. Now, anybody can present oral evidence at this hearing. So no one's prohibited from speaking. But if you are not a party and there's a process to become a party, you get 5 minutes to present your evidence, your oral evidence. But you don't get to examine witnesses, etc. And the findings and decisions. So unlike in a zoning where your motives are irrelevant, you don't have to say anything. You could all just stand and look at each other, including the applicant, and make a decision. And that's okay. Here, strictly based on evidence presented at the hearing. So you've got your hearing, there's your evidence presented, hearing is closed, decision has to be made on that alone. And findings of fact and conclusions of law have to be issued. So similar to your report, it's going to be similar to your report, except there will be a separate conclusion of law provision. So the question is, okay, that sounds great. That's interesting. Why do we do it? Well, we do it because of the distinction between contested case and non-contested case under the Missouri Administrative Procedure Act. Who cares? What does that mean? Well, it really comes down to a matter of finality. When is a decision final? When is the presentation of evidence final? And what we're gearing for and what we're trying to accomplish is the establishment of a contested case proceeding. I say we're striving for it because no one can declare it a contested case except for a court. And we haven't had a court do that yet. But that's what we're striving for. And the reason we're striving for it is this. One, we want to have an exhaustion of administrative remedies defense. What does that mean? Say, for example, the Planning and Zoning Commission denies a conditional use permit. If the applicant fails to file their appeal within 30 days, it's done. They cannot file a lawsuit in court based upon the Planning and Zoning Commission's decision. They are procedurally barred. It's called exhaustion of administrative remedies. They have to file that appeal to the city council. Second, even if they do file the appeal, if the city, when the city council makes its decision, they have 30 days to appeal that decision. And review by the court is on that record that was created. Meaning, all the evidence that was presented before the city council, that's all a judge gets to look at, generally speaking. And we want that to be the case. I've been in situations where an applicant came up and they were asked, why do you want this to be approved? And the answer was, I don't know, I just do. That was their presentation of evidence. Got denied, and then when they filed their lawsuit, all of a sudden, they had all sorts of new evidence that the city council never heard or got to look at. And it's frustrating because what you don't want to have happen is have the court say, oh, city council, you got to look at this one again because they've got some good points. Well, okay, that's fine, but we'd like to hear them. We want to make sure they bring up those points before the city council. The next is the courts, if you have a contested case and it's all on the record, the court's not going to substitute its discretion for the discretion of the city council and the city council's decision. The basis that they look at was the council, based on the evidence that was presented, was the council's decision arbitrary and capricious. All right. So the third type of action are ministerial acts. The easiest way to describe this, I've got all sorts of fancy legal mumbo jumbo here on what that means. What that essentially means is this. You got a box for each thing that this person has to meet. If you're going down and you're checking those boxes, if they check every box, you have to approve it. Period. End of story. This is no discretion. This is not looking at analysis of certain things. It is, they've checked the box, they meet all the requirements, and we're done. Generally, ministerial acts are plat approvals and building permits. There's some other ministerial acts, but from a zoning and building construction standpoint, building permits not necessarily being a zoning consideration, but those are examples of ministerial acts. It is truly, you are just checking the box. All right, I don't want to spend a whole lot of time on the Board of Adjustment because I'm coming up on my time, but I do want to point out, what their roles generally are. And again, like I said early, we have to have a Board of Adjustment to have zoning. Law requires it. I know sometimes there's a frustration because of these competing interests of, all right, we passed this zoning regulation, but now the Board of Adjustment is saying, we're not going to apply it, or we're going to provide an exemption to that regulation. Well, that's what they're there for. And the law says they have to be there for that purpose. The reason being, again, unique nature of property. You establish regulations that are good regulations and applicable regulations, but sometimes there's just a unique aspect about a piece of property that makes the application of that regulation a practical difficulty or unnecessary hardship, which are the two standards that are applicable for variances. There's two types of variances. You've got area variances and you have use variances. 99.99% of the variances that are approved by the Planning and Zoning Commission, or I'm sorry, the Board of Adjustment, are going to be area variances, setbacks, encroachment into protection areas. Use variances are, I know I'm zoned residential, but I want to use my property for commercial. Very, 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 very rare. You will probably never see that in your lifetime. And then they have outside of variances, the Board of Adjustment has a separate role, and that is to hear appeals of administrative decisions. So there are certain decisions, such as the approval of a site plan. They can appeal whether or not, or appeal of a ministerial act. If they disagree with the application of an ordinance, they can appeal that to the Board of Adjustment. All right. I've gone through a little bit of area variances. The standard for area variances is practical difficulties. And then there's use variances. The standard for use variances is unnecessary hardships. And these are the standards that have to be established to prove unnecessary hardships or practical difficulties. And again, it's not a hard and fast rule. The statute doesn't provide it. This is things that should be looked at. And again, the planning staff does a great job of identifying all of these issues in their recommendations and in the reports that are provided. And then again, the Board of Adjustment also considers appeals. And one thing that's interesting, you may or may not know that, there's a 5-member Board of Adjustment. 4 votes is required to grant any variance. And that's statutory. Statute requires that. All right. Board of Adjustment reverse wholly or partly or may modify order, requirement, decision, or determination. So that's the authority that they have. Judicial review is to court. Petitions must be filed within 30 days. So that finality of decision, that time frame, it's important, and courts have analyzed and appreciated that. Where I want to end here is a couple of cautionary tales on due process, because these hearings, the public hearings, the administrative hearings, are all done because of due process. You've got a property right. We talked at the beginning, is that zoning is in derivation of common law property rights. So zoning, by its nature, is an erosion of those property rights. It's a legal erosion of those property rights because public policy, it's good for public policy, but it is an erosion of property rights. So due process is an important component to make sure that we go through the procedures and take the time to review these that are required by law. And when it comes to, I'm going to use conditional use permits, but also the Board of Adjustment falls into this category too. Fairness is an important aspect of this. Procedural due process requirement of fair trials by fair tribunals applies to administrative agencies, including the Planning and Zoning Commission, including the City Council, including the Board of Adjustment. To defeat that presumption, and there is a presumption that there's fairness, okay? So you automatically walk in with a presumption of fairness, but that can be defeated. Burden of proving it by clear and convincing evidence that the board was not free of actual bias of the probability of bias. Now, I want to be clear on what bias is. Bias is not that I don't like it. Bias is not that I'm predisposed to be against it. Bias is unalterable prejudgment of operative adjudicative facts before the hearing. So if before a hearing, you're going around saying, hey, I am going to vote against this thing. I think it's horrible. There's no way I'm going to let this pass. That is unalterable prejudgment. because you've not heard a thing about it yet at a hearing from the applicant. You have to give them that opportunity. Again, you cannot like it. You can say, I'm generally disposed to vote against these type of things. That's fine. But you can't just say, I'm not going to vote for this period before the hearing. Reasonable opportunity has to be given for preparation and presentation of evidence bearing on any issues raised. Well, and the map also requires, just as an interesting point, if someone thinks you're biased or a member of the city council is biased, they have to raise that objection during the hearing and ask you to recuse yourself. If anyone wants to hear a fun story, I did that once at a hearing at a city, and it's an interesting story, but for another time. It worked out well for my client too. All right, so we've talked a little bit about bias, and I want to tell two stories that come from cases. This one comes out of Minneapolis. So city council was looking at a conditional use permit. Someone wanted to construct a 21-story multiple family complex where 2.5 stories is the permitted height. That's pretty far deviation. You think it'd be a pretty easy decision based upon the applicable standards and consistency and planning standards. Should be an easy one. Property owner asserted bias in violation of procedural due process in proceedings before the city council, specifically alleging that a city councilwoman and member of the Planning and Zoning Committee sent email communications to Zoning and Planning Committee and constituents voicing opposition, and made a telephone call to property owner advising that she intends to turn down the project. I think it's interesting and it's worth pointing out here that when we're talking about bias, it goes two ways, not just to the applicant, an ultimate prejudgment in favor of the applicant, because everybody likes to complain about, oh, they talked to, or they've already, the behind the smoky room deals that are made with developers and city officials. But this applies to the opponents as well, the neighbors. If you go out to the neighbors and say to the neighbors, don't worry, I'll vote against this, unalterable prejudgment is a problem. I mean, and to give you a taste of what this person was doing, she was going out and saying, I will advocate vociferously against the appeal. These are quotes. I assure you, I will do my best to advocate against the appeal in committee. And this is my favorite one. I serve on the plan. I mean, she put this in an email. I serve on the Zoning and Planning Committee, which is a quasi-judicial process. If I get involved prior to the public hearing, I could face giving up my right to vote on the issue, as the information I would receive would be outside the public hearing process. Please do not be spreading the word that I have made up my mind and am working to oppose the variance of this project. If the developer hears this, they will rightfully question that they didn't get a fair hearing with me and that I made up my mind prior to the hearing. So she was biased and not very smart about it to boot, and knew it. That's what kills me. She knew it. She knew she was doing what was wrong, put it in writing that what she was doing it wrong, and did it anyway. What the court ultimately did is, it's interesting because the court said, you know what? If they denied the conditional use permit, city council ultimately denied it. And the court said, yeah, you had some rational basis. You were reasonable in doing that. But because the decision was nonetheless arbitrary and capricious, because the council member took opposition and exhibited a closed mind with regard to the proposed project prior to the hearing, adopted an advocacy role in opposition to the project, and was clearly involved in an effort to assist and organize mobilized neighborhood opposition, we're going to say that the whole process was tainted. City council improperly relied on factors it was not intended or permitted to, those phone calls outside the hearing, and the decision would not. So they sent it back to the city council and said, do it all over again. Now, interestingly, at the trial court level, they filed a Section 1983 action, a civil rights lawsuit. And at trial, the plaintiffs won and got about, I think it was $300,000 in damages and another $300,000 in attorney's fees. On appeal, though, that was overturned, but not after considerable litigation expenses. And it's worth noting that the city's insurance carrier does not cover zoning actions. And the next one I want to talk about, and this is where I'll end, is Furlong versus City of Kansas City. This is actually a Missouri case. This was a plat approval. So the developer submitted a preliminary plat for approval to develop his land into a car wash and fast food restaurant. The staff approved of the plat, subject to some minor conditions which were met. This went back and forth with the Planning and Zoning Commission saying, okay, fine, we want you to do X, Y, and Z. If you do X, Y, and Z, that's what we want to see. So developer says, fine, does X, Y, and Z, shows it on the plan. Well, now we want you to do A, B, and C. Property owner says, fine. A, B, and C presented on their plan, on their plat. This goes on for 6 months. And after those delays, the applicant meeting all of the requirements. Remember, plats, ministerial, we're checking the boxes. Do they meet the requirements? They denied it. They're on record, and I'll mention this one. There's actually a statement in the case, a quote from the city attorney that, or it was the chairman of the Planning and Zoning Commission, and I know our chairman's a lot smarter than this, but the chairman of that Planning and Zoning Commission told the opposition, oh yeah, our attorney told us we had to approve this. And they didn't anyway. They provided no reason for the denial and no reason to opportunity to correct any of the deficiencies that frankly didn't exist. So unusual and extensive delays in reaching the decision. Property owner files a civil rights claim, section 1983. The administrative body's actions are truly irrational. So that's the standard. It's not, arbitrary and capricious is it arbitrary and capricious to deny it? Then the court may just say, all right, you have to approve it. But if the denial is arbitrary, capricious, and truly irrational, that may result in damages being imposed. To be truly irrational, the act must exceed the arbitrary and capricious standard. Intentional disregard of the law, knowing that it is disregarding the law, thereby depriving the individuals of a property right. And it's worth noting, good faith defense. So acting in good faith with the intention of serving those who elected you does not provide a defense to an action for damages. So saying, yeah, I know what the law was, I know what the law is, I know what the regulations are, but everybody's against it, so I voted no. Not a defense. It's not going to fly. In that case, and this was back in 2006, so we're talking 14 years ago. Plaintiffs were awarded about $175,000 in damages and another $150,000 in attorney's fees. So just a cautionary tale, a couple of cautionary tales on due process. That is the end of the presentation. I'm happy to answer any questions anyone may have.
Thank you, Mr. Young. Any questions? Everyone's silent.
I was just that clear.
Yeah, well, doing this from the other side, from the developer standpoint, we used a lot of what you said to get things approved. So this has been very good. Will
Mr.
you,
Young, if you don't mind unsharing your screen, Mr. Young, I'm sorry to interrupt.
yeah, what I was going to say, can you
I'm trying to figure out how to do that.
save this to where we can download it and keep a copy of it?
Absolutely. I'll make sure to send
Okay.
I
Thank
will
you.
send a copy of that. Let's see, stop share. There we go. All right.
Commissioner Broyles.
Thank you for that presentation. I think your vignettes, your stories were very helpful in aligning all of the information together. So applaud your presentation to us. Thank you.
Thank you. Appreciate that.
Very helpful in aligning all together. Those flaws are
Okay, we were getting some feedback. Any other questions? Commissioner Levitt?
Yeah. I did have a question.
We can't hear you on your connection. Mr. Newberry, any other comments?
I'm not seeing any of the commission members with their hands raised.
Okay. All right,
Mr.
well, go ahead. I thought we'd just move on.
I was just going to add, if Mr. Levitt would like to use the chat feature and ask his question there, we could read the question and be able to respond. Never mind.
Okay. Mr. Newberry, moving on to Town Center.
Well, Mr. Chair, thank you.
Okay, Mr. Moody.
Mr. Chair, members of the Planning and Zoning Commission, I do want to thank John Young for his presentation. As Ms. Broyles noted, it was very well done, and I think the personal experiences he's willing to share add a kind of character to what can sometimes be considered law that's a little dry. And so thank you for doing that. Members of the commission, as you know, over the course of the last several years, probably beyond that, going back to 2015, the town center area saw an increase in interest. And for a while, the Planning and Zoning Commission was being presented a wide variety of plans for new residential developments within the defined boundary of town center. Those developments have come to fruition, many of which are completed, such as Old Town Park, Bordeaux Estates Plat 2, Wildwood Trails, the manors at the Meadows of Cherry Hills, and the list goes on. The development of land in town center was expected, and for the most part, you as the kind of guardians of that gate are the first to see many of the proposed changes that are to occur. But as we've seen, a lot of the surrounding property owners were unaware of what town center area is, its extent, the rules associated with it, and its overall intent. So tonight, to help you respond to questions you may get from constituents that you represent by each of your 8 wards, the department has put a packet of information together. It's somewhat unusual, and that's intentional, in that it contains a lot of historical information. It includes, for example, the initial ordinance that established what is described as phase 1 of town center. And phase 1 was the designation of all commercially zoned properties or commercially used properties into the town center and establishing new guidelines, standards for them. Phase 2 took a while longer and included the development of a citizens committee. Phase 2 was necessary because there were a lot of questions about new urbanism in town center, and a lot of the residents that lived on residential properties felt that they might be pushed out, and that there were concerns about the interaction or the compatibility of town center uses with existing residential properties. Ultimately, through that citizens committee, much like you, volunteers, we went from a room full of 200 people questioning the necessity and the logic of new urbanism in town center to the night that it was adopted in February 1998 with 3 people there and 3 of them speaking in favor. So it's been a long process, even back then, to kind of bring the understanding of new urbanism to Wildwood, and then ultimately to have the ability to teach people about some of its benefits and some of its drawbacks. So you have Ordinance 415, which is the original adopting ordinance for the commercial properties. And attached to that is the plan that Andres Dewani and his team came up with in March of 1996. They started then at a charrette and ultimately provided to the city as a final product, I believe in April of 1997. Along with that information, there's a couple of other items that were provided that came from the first update of the town center plan that began in approximately 2008 and concluded in March of 2010. One of them was just kind of tying the town center into the master plan as one of the 5 conceptual land use categories. And then from there, it kind of talks about the town center as a vehicle to achieve certain goals that the original incorporators and subsequent elected and appointed officials have tried to maintain. Along with that, it gives a good chronology of the process to adopt the first town center plan and all the components associated with it. I think it's key to note that town center wasn't formed in terms of its boundary by accident. For logical reasons, starting as simply as this area has the best access relative to its roadway network, such as Route 100, State Route 109, and Manchester Road. It also has all of the utilities, including the important internet access, as well as water and sanitary sewer. Also, if you notice, it's the traditional hub or commercial centers of the Old West County, Grover and Pond. So there was a logic behind all of it to ensure that town center was built on a solid foundation. That foundation beginning back in the 1830s when Manchester Road was the first road that was approved by the state legislature to bring legislators from the city of St. Louis to Jefferson City. So it has a historical aspect to it. And that's kind of addressed, as I say, in that Town Center Advisory Group memorandum dated August 6, 2008. An interesting piece of information provided to you is a memorandum that was prepared by Jonathan Barnett. Some of you recognize Mr. Barnett's name. At the time he first came to Wildwood, he was the chair of the Department of Urban Design at New York University. In subsequent years, he became a department head at the University of Penn in their Department of Architecture and Urban Planning. Mr. Barnett served as the consultant on the update of the Town Center Plan in 2008 and wrote a kind of interesting memorandum to respond to some of the questions he was receiving from the volunteers, as well as the larger community, which included some of the property owners and developers that had worked in the city of Wildwood. I think it's interesting that the first bullet point that he identifies is town center is just not a commercial center. And he goes on to talk about a place for higher density residential development, to create a community center, so to speak, a place where people can gather, as well as maintaining the green qualities that exist everywhere else in Wildwood in the suburban, the non-urban, and other land use categories of the master plan. I think it's just an interesting piece that sometimes you think, well, I have questions, and are these questions unreasonable? Are they not necessary? And as you can see through the years, everybody that's worked as a volunteer, whether it's on the Planning and Zoning Commission or an appointed committee, have questions about town center, new urbanism, its success here or its lack of success here. So that's why that memorandum dated March 29, 2009 is provided. The next item is kind of just an interesting sidebar. It's a 11 by 17 size table of parking. It's all about parking ratios, and you may think, well, why is that important? Well, in town center with new urbanism, the intent is to create a walkable community, to de-emphasize the vehicle, and for all intents and purposes, bring the character of the area to the street, not for the vehicle, but for the pedestrian, the individual. How's that achieved? Well, there's a lot of ways, but one of the ways is reduce parking requirements, as well as increase shared parking opportunities. And so this table was prepared when we were doing the Great Streets Initiative for Manchester Road with the cities of Baldwin and Ellisville and the East-West Gateway Council of Governments. And each community did an analysis, and what we found is a lot of communities are overparked. They have way more parking spaces than their ratios required, and certainly might be necessary except for one day of the year, maybe around Thanksgiving or Christmas. But as you can see, the city of Wildwood has practiced what it's preached. The parking ratios for these uses that are listed would have roughly about 4,500 parking spaces. And as you can see, we've approved 4,800 through our process, just less than 10% more than what the parking ratio is required. And we are able to do that through, again, being smart about shared parking, on-street parking, and sticking to our guns about parking ratios and not over parking sites. The benefits to that. They're twofold, I think, beyond just adhering to the plan, are the design standards. First and foremost, less impervious surface means less stormwater facilities. And that's a good thing, because oftentimes stormwater facilities are not the focal point of a project. And then secondly, less parking spaces means more green space, which is highly valued in Wildwood. So now we're going to jump ahead a little. The next item is the current development manual. We've all probably seen this. And our Architectural Review Board spent a lot of time going through it over the past couple of years, particularly the end of 2017 and almost all of 2018. It is the nuts and bolts of what a person would look toward to see what is new urbanism and how can I apply it to a project or property I'm interested in developing or using. I will note that the current town center update team, which has been meeting since the end of 2018, has gone through each and every line and each and every word of that development manual. And shortly you'll see a revised version for your consideration and action. The next item is an April 9, 2019 memorandum prepared by the department to the town center update team, the current group of volunteers updating the plan. And they had a question about the logic of the boundaries. And so I thought it might be interesting just to provide that to you all so you could see what the logic behind the boundaries were. And again, I always like to emphasize there was not a lot of luck or let's just try. It's all about using good sound planning practice, as you've all done as planning and zoning commissioners, to come up with the best approach to the boundary. And the final item is just a series of maps. And with Mr. Newberry's help, I'm going to share screen the two maps of the town center area so you can see those. We could go to the next one, Mr. Newberry. So members of the Planning and Zoning Commission and those in attendance via Zoom, this is the current town center boundary with the land use districts overlaid within it. This is called a regulating plan. It was one of the 5 major components of the town center plan. The other being the boundary map, which is included here, the boundary, the street network map, the regulating plan, what you're seeing now on the screen, the neighborhood design standards, and then the architectural guidelines. I think this map is illustrative in several ways. The first is our town center is big, just in terms of acreage. It's over 800 acres in size. As noted in Mr. Barnett's memorandum, that's greater in size than Newtown in St. Charles, which is a project that has substantial number of units and different types of activities associated with it. Also, I think it's interesting to see that when the boundary was established and the regulating plan districts laid down, it recognized, as John Young mentioned, the surrounding land uses associated with it. So wherever there was existing residential, the city council, the planning and zoning commissions, and others that preceded you tried to put like uses next to like uses, so as there would be an appropriate transition. Along with that, those decision makers also retained the Pond Historic District. It's an important note because the Pond Historic District does have a definable boundary, and it is an area where a lot of the historic buildings and structures have survived. And so it was key in their decision-making process to retain that. That's why we have what sometimes referred to the tail on the donkey. The downtown district, which is the kind of brown or beige color, that has become the core of Wildwood. That's where our Deerbergs is. That is where our Schnucks is. That is where the Walgreens is located. It is the most intensive land use, but for all intents and purposes, it is where people gather more often than not. It is also where the city of Wildwood, purchased property for City Hall, and where we purchased property for our new Village Green. So the downtown district can be considered the heart of town center, what kind of drives everything else. And all the other land use districts support that heart, so to speak, through lesser intense commercial projects and all types of residential and institutional uses. I think that's the concluding factor on this particular map I would like to identify. Think about it, in 800 acres, we have a community college. We have the Wildwood Family YMCA. We have an elementary school. We have an old pond school, a historically restored one-room schoolhouse. We have the Metro West Fire Protection District headquarters. We have historic properties in Pond. We have 2 major supermarkets and the centers associated with them. And we have all types of residential, from Canberry, where we have detached single-family dwellings and attached row houses, to now Brightleaf, which has some larger suburban style lots with very significant sized homes associated with them. So it's a really diverse area, and it's very different than the rest of Wildwood from the standpoint of the suburban, non-urban, industrial land use categories. And it really sets the tone and provides the protection to preserve those other areas from intrusions that are unwanted by our residents. The next image, and I've mentioned this, the Town Center Update Team. It's a group of volunteers updating the plan. They have recommended slight additions to the town center boundary. And after much discussion and over probably 8 to 9 months of time, those areas with the lines, the shaded patterns, those are being recommended to be added to the town center boundary. What they did, though, is they created a new district called Neighborhood Edge Transition. And the thought is we have properties that abut existing town center area where the uses are significantly greater than what would be allowed under their current land use category under the master plan. For example, the abutting properties are designated for 1 unit for every 3 acres primarily, single family residential. But in the case of the one that Mr. Newberry is highlighting, it adjoins Grover Crossing, which has up to 6 to 7 units per acre and commercial development around it. To the west, you have an area that's highly institutionalized, number of churches, schools, etc. And the thought is to accommodate a little higher density pattern, but certainly not one that's too great. So in the neighborhood edge transition, you can have 2 units for every 3 acres instead of just 1. So in density of 1 unit for every 1.5 acres. So as you can see, the town center boundary on its second update, over 20 years of application, hasn't changed much. And I think that reflects on the success of the concept of new urbanism and the work of planning and zoning commission members like you. I'll conclude my presentation by just stating, when the city of Wildwood Incorporated, and tomorrow is our 25th anniversary, there was a lot of concerns voiced throughout the community about the vitality, the viability of a community like Wildwood. Wildwood didn't incorporate easily. There were a number of court cases, one actually reaching the state Supreme Court. And so the litigation was a concern. And many of our consultants, not me, people much smarter and with greater experience than I, simply stated that to impose a 3-acre requirement throughout all of Wildwood, you would, for all intents and purposes, place yourself in a very difficult situation regarding exclusionary zoning or the lack of diversity associated with the community in terms of housing. The town center became the place where we could offer any interested party an opportunity to look at different types of uses, whether it's apartments, row houses, condominiums, single-family detached dwellings on smaller size lots, etc. It became the buttress for the rest of the community to stay the way it is. And it's been very successful at that. So with that, you have a lot of materials that I've provided to you that gives a little historical perspective. You now have some of my opinions along with the history that the city's experienced over the past 25 years, or now 25 years of its existence. And hopefully you have a little bit better understanding why town center seems to always be in the middle of the target when conversations are held about land use, tree preservation and restoration, grading, and all of our other regulations. It's not that we ignore them here, but we also have a land use plan that dictates that we can be a little more flexible in how we do things here, because a lot of the characteristics in town center are more favorable than anywhere else in the city of Wildwood. So thank you for your attention. And I believe Ms. Arnett, Mr. Newberry, Mr. Young, and I are all available to answer any questions regarding town center, how we do things here. And again, Ms. Helfrey or anyone else that's participated in the town center update team would like to speak about it, I'll mute myself and be quiet. Thank you.
Thank you, Mr. Vunich. Any discussion items or questions from anybody? Commissioner Broyles. You're on mute there.
Sorry. Thank you, Joe, for the presentation and the background of Wildwood. I've been here since it was unincorporated, so, but didn't have many facts in the beginning. But I want to look at the map the 2019 map that T-Cut was working on. I know Vicky's on that committee. There may be some other people. The next one. The 2019. Yes, thank you. The lines, we traveled as a group on that committee to these areas. And it was my understanding, and I may not articulate this as well, but we were looking at not making Wildwood Town Center, trying to keep the housing and the building so concentrated that it was kind of a buffer in a way. Could you articulate that better than I, please?
I think the word you've used, buffer, is an excellent choice. I guess I would describe it as you're at the edge of a cliff looking down at a 200-foot drop. That's how the property owner, for example, over on Manchester Road near Woods Road kind of felt. I've got a project next to me that has 6 to 7 units per acre, but you're telling me I can only have 1 unit for every 3 acres. How does that demarcation meet the standard of logic? And for the most part, the response was, well, there's always going to be situations like that, and those are the ones that most people just have to accept. But in this case, the group came up with I think a great solution. It was, well, let's do a transition zone where it's not 1 per 3 acres, but it's not 6 per acre. It's actually 2 per 3 acres. And knowing this site, which again, Ms. Broyles mentioned, we did site tours of all these locations. It works pretty well because the south 20 acres just is very topographically challenged, whereas the front 20 acres is much like Grover Crossing, more flat and usable. And so I think buffer is a great word you've used, Ms. Broyles.
And what about if you could describe the western part of that extension, that proposed extension?
Well, there's 2 parts to the western extension. One is the Slavic track, and the T-Cut, the Town Center Update team members, thought that it should be substantially de-intensified from what its commercial zoning was back in 1989, but also based upon what the Reserve at Wildwood is proposing, 130 plus lots. So they designated the Slavic tract, that 50 acres, as neighborhood edge transition, and carried it forward to what I consider is a very logical conclusion, which is Pond Road. And Pond Road is a good boundary because to the west of Pond Road is Living Word Church and Wildwood Middle School, which are 2 institutional uses that'll be there for a long period of time, assuming that all is well. And so it was a logical boundary. And there's a parcel of ground in that area west of the Slavic tract that's about 30 acres, has a nice ridge line. And again, we were able to determine all of this by doing the site visits. So in both instances, I think we were looking at buffer, and we were also trying to be cognizant of logical boundaries and topography. Thank you.
Thank you.
Any other comments?
I believe Mr. Beatty has one.
Mr. Beatty.
Yeah, Joe, can you remind me what the suburban density is right now?
It's 1 unit for every acre of ground.
Okay, so I don't know, to me, this town center transition seems to be, I don't know, the fact that it's less dense than our standard suburban zoning seems to be out of whack a little bit. Why not just call it suburban? I don't know. But
So, pardon me.
go ahead.
It's an excellent question, and it's one that the town center update team debated as well. Their charge is to update the town center plan, but I think at the conclusion of the discussion, the overall statement to the property owners was, if you want suburban, which would increase your density, then go through the master plan process.
Mhm.
So we didn't negate that. We just couldn't do it because they were looking at town center.
Okay. Yeah, I mean, to me, like, to be in the, I don't know. So you guys all know I live in the town center. I like the density. I like my 8,000 square foot lot. I understand the people outside may like their 3-acre lots or whatever. I'm not here to build tight subdivisions out in the rural areas, but I have a concern about the de-densification of the town center. Being that's why I moved here. I like the density. I want to be able to walk to stuff. And 1.5 acre lots inside the town center seems kind of backwards to me.
Well, again, within the confines of the current boundary, I probably concur. I was not an advocate for the Slavic tract, knowing its past zoning history
Mhm.
and its proximity to 2 arterial roads maintained by the state of Missouri.
Also, the 2 schools where dense homes, you could have a whole lot of kids being able to walk to school.
Understood. And again, that may be an option for the Slavic tract, which extends all the way down to Manchester Road, just across from the New Pond School.
Mhm.
But I'll go into more details about the Slavic proposal, what the town center update team is recommending, et cetera, this coming Tuesday, a week from tomorrow, when the Planning and Zoning Commission meets again. Obviously, I have concerns about the intensification of town center. I know people are concerned about housing density and the change that development brings. But there are a lot of good reasons, not only in the town center plan, but in the master plan that talk about life cycle housing, availability of different types of housing, availability of different price ranges. And I know you all hear this, but I'm here and I like what I see. But someday there may be a child of yours that wants to live in Wildwood that can't necessarily afford or want a 3-acre lot. Where do they go? Well, they go to neighboring communities, and those neighboring communities benefit from that youth, that vitality, that kind of, I'm hearing we're going to make this a great place to live because they're young. And then a lot of our initial incorporators, I can name one, Sue Cullinane, lived on a 3-acre lot in the Indian Tree subdivision. When her husband and her were ready to downsize, there was no place in Wildwood for them to go. They now live in Chesterfield. And that just doesn't seem right to me, because without Sue Cullinane and many like her, there wouldn't be a Wildwood. So you've got to study it not just from a perspective of what are we doing to the woodlands, what are we doing to the stormwater. We've got to look at it, what are we doing about the future of our community? Where do young people, where do seniors, where do those that may not have a 6-figure job end up if they want to be out in Wildwood? And that's the center. And there's a lot of social engineering that went into town center. And I think it's reflected again in our master plan and our town center plan. Not all proposals are good. I'll be the first to tell you that. But every once in a while, when a good one comes by and it's a little different than what everybody's used to, we shouldn't flinch just because somebody says, I don't like it. Let's hear why you don't like it and see if we can fix it.
Thanks, Joe.
So,
Appreciate it.
yeah, Mr. Bunich, so this will be a recommendation from the committee, and then we will take action upon that, either agreeing, modifying, or denying it, basically. And then it's sent on to council, right?
Well, as Mr. Young noted in his presentation, you adopt the master plan and all of its subcomponents, which the town center plan is one of them. So you'll have a public hearing, you'll accept public comment. We can go out and do tours of the properties. We can go out and meet with the property owners. You can take as much time or little time as you need, but you'll actually adopt a final version of the updated town center plan. It goes to city council for receipt, filing, and then endorsement, and what I would consider adoption in a different way. But yes, you are the primary authority, at least in terms of the plan.
So any recommendations that we would make to modify their recommendations would become the modified plan.
You betcha.
Okay.
A lot of authority you all have in this regard.
Any other comments? Seeing our Commissioner Broyles. Oh, you're still on mute.
Vicky's on that committee as well. And I think we learned a lot, and we had a lot of discussion on this, and I look forward to discussing it further with this group next week.
Commissioner Jackson.
Any of the discussions that we're having now with the town center impact any decisions with this coming proposal for the development that is around the fire station and et cetera?
Yes, sir. The town center update team is recommending that on the 50 acres, instead of potentially 130 lots, they're recommending, for all intents and purposes, an amount of about 50 lots.
So that's back to the 1 acre thing that Mr. Beatty was talking about, essentially 1 house per acre.
1 house per 1.5 acres.
So is it smart to take this matter up first before we even address that other matter? Is that the plan?
Well, the Planning and Zoning Commission forwarded the reserve to the town center update team for its recommendation, which was completed and then returned to the Planning and Zoning Commission. So we followed the process previously established by the commission members. And I think at this stage, after 5 years, I'll do my best to explain what the town center update team rationale was, but I think it's up to you all now to basically make a recommendation.
Well, my concern is if we were to modify by chance from 1 acre and make it more dense per Mr. Beatty's line of reasoning today, then that changes the whole development plan. It could put it back to 130 versus 50.
Well, remember now, the town center update team has just made a recommendation, and it's not their final recommendation. They were asked to just give their opinion. The current regulating plan for this would authorize the 130 plus lots. The one that's been adopted is in the book, so to speak. And so, for lack of a better term, the plan document. What you have before you is an opinion from the town center update team about a different approach. You can use that opinion or you can stick to the plan.
Okay, that's good to know. Thank
Yeah,
you.
so just to let everybody know, and Joe, put the original town center map up on the screen because that's the underlying ordinance that we have today. So we have much higher density in those areas right there.
Mhm.
And then the boundary stops to neighborhood edge, which is a different zoning, the neighborhood edge transition. So, we have to look at this development based upon this regulating plan.
Okay.
Mr. Jackson, excellent question, though. Thank you for asking. And as I say, Mr. Newberry, Ms. Arnett, Mr. Young and I will do our very best to give a good explanation on Tuesday night. It's one of only 2 items on the agenda, and so we'll have ample time if you want to go through the reserve in very much detail. I do want to thank you all again. I appreciate Fifth Mondays for the flexibility and freedom they give. So for you all to give it up, I just want to say thank you again.
Thank you.
Thank you, Joe.
Thank you.
Kathy,
Appreciate
and
the
Travis.
information.
And to John Young, thank you for being here on a Monday night.
Mhm. That was very, very good. All right. If we have any other discussion items, I'll entertain them. Otherwise, I'll entertain a motion to adjourn. Commissioner Broyles and a second by Commissioner Levitt. All those in favor say aye.
Aye.
We are adjourned. Thank
Have
you.
a great Labor
Night,
Day
thanks.
weekend.
You
Thank
too,
you.
Joe.
Good night.
See ya.